Next item on the agenda is the second read of the senior lawyer's proposed change to the Washington State Bar Association bylaws. Do we have?
Yes, good morning.
Good morning. Eleanor Dorman's here to speak about this.
Yes. So good morning, governors. I'm here today with my fellow senior lawyers executive committee members, Paul Grayson and Brian Comstock. And we attended the September BOG meeting to present this proposal for its first read. And at the time, your response in September was generally favorable with a few requests for some clarifying language. So since that time, we've worked with advancement staff and the Office of General Counsel to address those clarifications. And we present those to you today in the hopes that we can get your final approval. So to summarize briefly the proposal, WSBA bylaws currently do not allow inactive members to be voting members of sections or to be elected to executive committees of sections. And so the senior lawyer section is proposing changes to Articles 3 and 11 of the WSBA bylaws in order to give each section the discretion and authority to decide for themselves whether members with inactive status can be voting members of the section or serve on the executive committees. And given the particular demographics of our section and many of our members are retired, this matter has a particular impact on our section and is of concern to us, but it applies across the board to all sections. As you may remember, prior to the last presentation, we had done a poll of section leaders, and the response was almost entirely in favor of this proposal. And so just to sum up the changes since the first presentation, in Article 3, the updated language makes it clear that we are only addressing the ability of inactive members to vote or hold office in a section. So this does not apply to ability to serve on other WSBA boards or committees. And then the Article 11 revisions are more clearly define which statuses fall under this category of inactive. And those are inactive, disability inactive, and honorary. So this is not addressing judicial members, and we understand that is a separate issue. So I'm happy to answer any questions you might have. We're hoping that these clarifications take care of concerns that you might have. Many thanks to Kevin Placci for working hard on this with us. So,
any questions, governors? Governor Angeville.
I just have a comment. I think the work that was done on this is incredible. I personally believe that it is important for us to be inclusive of all of our members, especially our members who have such a wealth of experience and background, regardless of whether they have status as active members. So I support these changes, and I hope that we're gonna support the redraft of this. Thank you.
Governor Adwale.
Thank you, Mr. President. I also support this, but however, I still have some concerns. Members can be active, they can choose to be active, or they can choose to be inactive. I do recognize specifically for some sections, not all sections, for some sections, there may be a need to be able to have voting powers for senior, learned colleagues that have really held this profession in high esteem, and they still want to participate. They contribute a lot to volunteering work, especially in access to justice. So I do agree with that. However, yes, I do agree in giving them voting powers in certain sections that are relevant, where they really can contribute a lot. My concern has to do with making them chairs and co-chairs. Active members paid to be members of WSBA. And I still believe that that's put a lot of onus on us who are fiduciary of their money to ensure that people that have a stake, a skin in the game, are the chairs and co-chairs of our sections and our committees and our subcommittees and all of that. I'm not discounting the experience that it brings to the table, but I still have a lot of concerns about extending it to a point where an inactive member get to be the chairs and co-chairs of sections. I'm really I need some more explanation on that. I don't mind them having voting power since they contribute a lot of their experience, but being chairs and co-chairs worries me.
Thank you, Governor Adewale. Any other governors? Any response from the presenters? Oh, I'm sorry, Governor Stevens.
Yes, Mr. Chair. I'd like to move approval of the bylaw change. And if there's a second, I'd like to speak to it.
Okay, it's been moved by Governor Stevens and seconded by Governor Pertzer to approve the bylaw changes. Governor Stevens.
Yes, so, and this is in part actually in response to what Governor Adewale said. So as I look around, and I'm talking about our sections especially and other volunteer boards, we have an issue with people not stepping up to do the work. And yet we have this wealth of inactive members who are not interested in doing, quote, legal work, but interested in doing the educational and other work that sections do. And so there, I see this proposal as a proposal where, quote, so-called inactive members want to give their time and their talent to various sections. And I look, for example, at a section that's near and dear to my heart, the Civil Rights Law section. And I'd like actually Director Platchey to speak to this as well. But I know we have had issues of late in terms of people stepping forward to be in section leadership, which is unpaid work. And if we're talking about member engagement, I think we should actually expand that to allow, and especially, I know the senior lawyers are proposing this, but for any section, for people who have given a lot of their time and professional efforts in the various subject areas, it would be unfortunate if sections said, well, yeah, that's nice, but we don't want you voting and we don't want you leading. And so we just like you showing up. But we're just talking about what sections do and what sections can do. And I think this is a welcome change, especially since it's just limited to the work of sections. Thanks.
Okay, I think Director Platchey, I think you had your hand up next.
Thank you, President Tollefson. I wanted to answer some of the concerns or speak to some of the concerns of Governor Adewale, and Governor Stevens has addressed some of those. The first thing I was going to point out is this proposal of the bylaw change only applies to sections. And additionally, it doesn't force the sections to do anything. So what the proposal is saying is, if a particular section deems it appropriate for their section, they can take action to change their bylaws to allow inactive members to be voting members of their section. But the sections have to take specific action to change their bylaws in order to do that. It's not requiring it of all sections. So there is some discretion built in there. The other thing I would say to the inactive status part is really there's kind of two groups that this applies to. One is just purely inactive when someone's on inactive status. And even on inactive status, members still pay a license fee to belong on inactive status. So they're still paying around, I believe it's $200 to be an inactive member. So they do have some financial sort of skin in the game there. The other thing I would say is the only inactive status that doesn't pay a fee is honorary. But in order to be honorary, you have to have been on active status for 50 years with the bar. So you have certainly invested something by that time by being a member in active status for 50 years. So I just wanted to answer those concerns and really point out that this isn't forcing the sections to do anything. It's allowing them the opportunity to expand their membership if they would like. And then one final thing, I will say sections have been experiencing a decline in membership over the past few years. And hopefully by widening this scope of who are allowed to be section members, particularly voting members, could help improve section membership as well. So thank you.
Governor Higginson, you had your hand up. Were you wishing to speak or no?
I was, but I've decided not to say anything.
Okay.
Thank you, though.
Governor Adwale, you have your hand up.
Yes, Mr. President, and thank you, Director Plachi, for addressing my concerns. And I want to say that I respect and honor the senior practitioners in our profession that have got us here, and their leadership is treasured. My concern is with inactive members who, according to Kevin, paid, and sometimes they are active, sometimes they are inactive, they are younger people, they live out of state, and in fact, some of them try to run for governors. They change status frequently, and they want to run for governor, they want to be chairs of sections and all of that, even though they do not practice in our local jurisdictions and know the challenges that attorneys face and those sections face. But Director Plachi seems to have addressed my concern with the fact that the discretion still remains with the sections to be able to determine, because what I'm afraid is once we open it up for sections, it's eventually going to get to other areas and committees and all of that. And I want people that are experienced to be able to continue to participate in our profession, especially people that have served this profession very well. The ones that I am a little careful about are inactive members that are out of state and do not really care about what is going on, but just want to come and, just start a raucous or something like that. Those are the ones I'm really concerned about. But Director Plachi seems to have addressed my concern. So I'm okay with this. Thank you.
And I might just add that, the leadership positions, and I can vouch for this, take a significant amount of time in a section. And that oftentimes that people who are in the example of senior lawyers in a retired position may have more of that time to give to that role. And so I would hate for them to not be eligible. Thank you.
Thank you. I've been reading the materials since the first presentation and listening today, and I still, and as much as I value the seasoned experience that comes with 50, 60 years of bar membership, I am reticent to open this position as I believe, one, that it's going to be the slippery slope that'll then lead to a complete determination that we start with section membership and section leadership. And then it's going to be, because again, the very first amendment as it relates, and I can't remember the specific section, but it says can vote in bar matters. It's not limited to just the sections. I mean, there's the section, but in the bylaws, the very first, and I think it was the Article 3, what page is it? Where, yeah, it says inactive members. It just says inactive members may be eligible to vote in bar matters or hold office therein or serve on any committee or board. And so it's, you know, now we're going to, I mean, it's as much as it's being said that it's tailored to just be sections, I disagree with that. I believe that the amendment there in that first section in Article 2 inactive can serve on any committee or board. Okay, so let's just be very clear about what the language is and not try to garner support by saying it has artificial parameters that it does not, in my view. But then also realizing that when you're in active practice, even if you're part-time or mostly retired or of council someplace, you're still getting the insights of your colleagues and seeing what's going on, as where if your only engagement with the legal profession is through a volunteer service in a section, you know, I will never forget my very first job offer in 2002 from an attorney who had not been involved at all with the legal profession, the legal education community in the 20 years since he'd been out, and didn't understand the cost of education and why I had to laugh at him and deny and reject his offer of employment when I was being offered $24,000 a year, because he had no concept as to what was the cost of legal education. And I just am afraid that as people retire and decide to, you know, come and still contribute, that there's not going to be the active knowledge of where we are with technology in the courts, with what's happening, if all you're doing is being involved in the section. And maybe it's because of my own lived experience where I've dealt with elderly people who basically stop feeling that they ever need to learn. And so they are stuck with the way the world was when they turned 62 and retired. And now they're 80 and 20 years have gone by and they still are holding beliefs and using words and terminologies. And so I will tell you, this gives me great pause and wonders where it's going to go. And if we're going to be looking at a situation where, you know, 5 years down the road, we're going to have 13 members on the Board of Governors who are all 75 years old and retired and haven't been in the active practice for 10 years or so. Not that that's terrible. I believe, again, there's great insight, but I'm also trying to find another organization in my mind where inactive members, people who are no longer full-fledged members, are given the ability to control the outcome with votes. And I haven't thought of one. So that's my thoughts on that.
Yeah, so I'm here representing the new and young lawyers, but I'm going to go to the opposite end of this for a moment and ask, as we have these conversations, I understand the concerns of this expanding. Even as it expands, though, I ask myself, what's the harm? Those of you in the Tacoma area may know an attorney by the name of Julia Lindstrom, who had retired and had been acting as a pro tem judge for some time, and thankfully recently left that job to join my office. I have a very, very tech-forward office. She was entirely unused to that, had not done civil practice, and had no experience in this area, but she wanted to learn, wanted to do something different, and she came and joined me, and I am very grateful that she has joined me and continue to be so. I understand the idea that this could expand, and I think if it proves viable in the sections, that it will likely expand to other areas. And if it proves important to the sections, then it will expand, but it will only expand if what we get out of this is a successful test where the sections are finding that people who have an inactive membership are really beneficial to the sections. If someone with an inactive membership runs for the Board of Governors later on because this law is expanded and garner the majority of the votes, then I think it's hard to say that they shouldn't have the right and they don't have a mission that is clearly resonating with the people who are voting. It seems like it's not arbitrary because there is a line that is being drawn that I understand between active and inactive membership, but I fail to see what the harm would be that would come if someone comes to this table as someone has come to my office who does not have the knowledge of how things might be currently presiding. I'm a firm believer that everyone who works to come to this table to do a thankless job has a desire to learn and an interest in learning, and that alone will guide them to be successful in this position and to learn the things they need to learn. And again, especially, you talk about the Board of Governors or the sections, at least as far as the sole and small practice section is concerned, are elected positions. People will have had to support this person who has an inactive membership and believe that that person is their best representative for them to win. So I understand concerns, but I really fail to see where the harm is going to be if this does expand. So that's all. Thank you.
Thank you, Governor Couch. Is there any other governor who wants to speak? We got some other people that want to speak, I know, but I just want to make sure that any governor who hasn't spoken has an opportunity to speak. Okay, I think we're up to Director Platchey again then. Or were there? Oh, Governor Higginson. I'm sorry, you've got your hand up. As does Governor Stevens again, but Governor Higginson first.
Thank you. I decided I would like to say something about all this after listening to what's being said. I have to agree with Governor Williams-Ruth about what's going on here. I will just preface this by saying for the senior section, lawyers section, I'm probably eligible for it. I'm 66. I've been a lawyer for 41 years. So this is not coming from the perspective of somebody who's 27 and has been in practice for 2 or 3 years. But I do think that there's a really big difference between somebody who has chosen to go inactive and somebody who is remaining active. It's not just the difference in what people pay for dues, but there is, as Governor Williams-Ruth said, I believe there is a different perspective for somebody who is still in the trenches, who is working actively in the profession, who has the benefit of seeing what's happening with colleagues, talking to them on a day-to-day basis, working with clients, and that is a different perspective. And needing to keep up with developments in the law and being in touch with what attorneys might need. And we are here as an organization, of attorneys and some other legal professionals to help them, I believe, and serve them. And we can't do as good of a job if we don't understand, if we're not one of the people who is actually actively working. Now, I may have a wealth of experience from the past, and I respect that entirely. And I hope someday when I retire, people will respect the fact that I have a wealth of experience. But will I have the same view as when I'm no longer working? And I don't think I will. So I will say that I think that this is probably not the right way to encourage additional participation in sections. I don't know exactly why sections membership is declining. Some of them are very robust, some are not. But I imagine that this member engagement survey that we're about to undertake will give us more information about why people haven't been as active. This just feels to me to be the wrong way to approach that particular problem. So I need to honestly just state that I am not in favor of this bylaw change. Thank you.
Before I get to Governor Williams-Ruth, Director Platchey, you've had your hand up for a long, long time.
Thank you, President Tollefson. I just wanted to respond to a couple of Governor Williams-Ruth's concerns. So the verbiage in the red lines I wanted to point out were exactly what Governor Williams-Ruth stated were vague. And that was pointed out in first read. So what we did is went back and worked on that language. So there are 2 Article 3 red lines in your materials. One references a first read, one references for second read. The second read red lines are the ones that are before you for action today. Those second read red lines for Article 3 took care of the vagueness of the may be eligible to vote language. They specifically say, instead of saying may be eligible to vote, they say inactive members are not eligible to vote or hold office therein or serve on any committee or board, except an inactive member may vote and hold office in a bar section if a section's bylaws permit. So it's very clearly stating it applies only to sections and only if sections change their bylaws, and specifically says it doesn't apply to committees or boards. So that's the second read for Article 3 that was submitted to you. The other thing, and these materials start at page 40 in the regular materials. The other thing I would point out is in our first memo, the one we brought forward for first read, we did do some research of our other bar associations. And in that memo, we pointed out that some surrounding bar associations, integrated bars, do allow this very thing. So Idaho and Utah particularly don't allow members, inactive members, to serve on their bar committees or boards, but they do allow the sections the option of allowing inactive members to join their sections. And that is in the memo in the materials, and we link to those bylaws so that you have those available. So I think that's a couple of the concerns that Governor Williams-Ruth raised that I wanted to address. So there is precedence with other bar associations for allowing sections to allow inactive members to join them. And the language, the ambiguity in the language is what we did resolve in the red lines for the second read. Thank you.
Okay, Governor Williams-Ruth, you have your hand up again.
Thank you. Mr. Director Platchey, appreciate you directing. And for those who want to know, page 66 is the second read. I had not seen that part, and I appreciate that adjustment. It still does not change my necessary mind. And I want to speak to Governor Couch's comments, and it actually stems from his own experience in attending a conference in the last couple of weeks that was really about moving the practice of law forward and the use of technology. And again, my own lived experience in that my very first Seattle-based attorney job was for a firm that was 100 years old. It had been through 2 generations of families. The 2 brothers or 2 friends started it, then their kids kept it going. By the time I got there, there was only 1 left of the original named partners. And in 2002, I walked into a firm that handed me a dictaphone and a secretary that did machine transcription. And when I said, you know, there's this great new device called a BlackBerry, and that will help me stay in touch and be able to do my messages, but not need to be chained to a desk. And they said, no. I said, well, what if I just pay for it myself? I really would like to try and move this forward. And even just getting the IT person to allow a small change to the network that allowed for the BlackBerry to work and interface almost took, it felt like an act of Congress. And it is that reticence that I am concerned about, in that the entrenchment of how things have been done and how things have always been done. And where I have really been moved in the last month in seeing Governor Couch's comments from this Clio conference that he went to and serving on the licensor task force, is that we're going to need real blue ocean thinking here going forward. It's not going to be necessarily about what's been published, what's been researched, what's been done by another state. I appreciate the insights of what others have done. But again, I can just sit here and ramble off 5 or 6 different substantive differences between the state of Utah and the state of Idaho and Washington state. And so I just want to make sure that as we're looking at where we're going and the comments that I have been receiving regarding things such as our EDI efforts, and diversity and inclusion, as well as the practice of law. I mean, the number of people, I've frequently said that one of the major benefits that COVID had on the legal profession is it forced senior attorneys that have been holding firm leadership to invest in technology because they had no option. And maybe it was just my own experience working with insurance defense firms before I moved forward, but investing in new technology and new ways to do things better, especially for an access to justice reason, never moved the needle in the firms I was in. And so that is what the harm that I see is if we, again, people who have chosen to take a $200 savings or $250 savings off their bar dues to become inactive and are no longer practicing, but yet still being able to hold a section meeting. And I love our sections. I had the most amazing interaction with the executive committee annual retreat for RPPT this past month. But what I also know is that I'm members of sections and they were taking positions on legislation and issues that never were ever even disseminated out over the own listserv of the section by the section leadership. There's no vote. I mean, when we're talking about moving section matters forward, it's the vote of the executive board, not the membership of the section. And so that is my fear of what's going to happen, is that there's going to be wonderful volunteers who have lots of time, but then the rest of the section, I mean, the number of section executive leadership does not necessarily reflect, and we talk on this board of governors about reaching out to stakeholders and what the members would want. There's no requirement that executive committees of the sections have to reach out to their own section members to find out what they want. So that is where, again, I just have this concern that people who have chosen not to be active members, giving them the oar that can change and direct the ship is something that I'm just not comfortable with.
Governor McBride, and then I believe we're back to Governor Adwale for a third time. Oh, Governor Stevens also.
Great. Thank you, Mr. This is working now, Rex? All right, hold on. All right, how's that? Better for everybody? Thank you, Mr. President. I just want to say that I took a lot of notes at the first reading of what we asked the senior lawyers to do and what we asked Kevin Plashy to do. And I felt like they responded to everything we raised. And I really like the process. I also serve on the committee that tries to fill all these volunteer positions. And it's hard. And we get a lot of no applicants. So I think this is increased participation is healthy. I agree with Governor Couch's point that even if you don't want that increased participation, I just don't see a downside here. So I hope we support this. I hope we at least acknowledge that this was a section that was very responsive to the Board of Governors in terms of completely reworking a proposal they'd worked on for a year. We're actually quite invested in, and then we're responsive to our concerns. So I hope you vote for it.
Governor Adwale.
I think Governor Stevens is ahead of me, and I don't think I need to make another comment unless it's something else come up.
Okay. Are there any other governors that wish to speak before I turn back to Eleanor Dorman, who I know wants to say something else? Oh, Governor Stevens again? Or did I miss you? I'm sorry.
That's all right, Mr. President. So as I listened to this discussion, and someone even talked about DEI. So one of my concerns is the level of ageism that I'm hearing, that I'm troubled about. And I would hope everyone would be sensitive to that, regardless of what your individual issue may have been with your individual story. The thing about this proposal is that the sections get to decide whether or not they're going to allow that to happen. And I hold them as able. I hold them as able to not go down a path that says, hey, we're going to decide that we're going to have the takeover of the old folks to run our section, as opposed to perhaps this person who has contributed many years and can still contribute, but leave it to the section to make that decision. It is most unfortunate when I hear some of the comments that we're making about senior lawyers. We are not all feeble. We are not all Luddites. We are not all just limited to the past. And let the section make the decision that this person or that person can be of value to our section. So that's all I have to say, but it is really troubling, some of our comments about inactive members, many of whom are senior lawyers. And no, Governor Adewale, I don't think a section is going to say, oh, we're going to allow this person who lives in another state and hardly deals with us to now become a part of our executive committee. I don't think that's going to happen. I think it's really going to be people who have given the service and want to continue to give the service, not the other way around. And this is so limited. It is a specific carve out regarding the sections, and it puts it in the section's hands. So when Governor Couch says, what's the harm? And Governor McBride says, what's the harm? Well, I also say, what's the harm, especially with the limitations that are made? And by the way, in terms of the slippery slope, we are the guardians of the slippery slope. Someone would have to come back to us to make another request for a bylaw change, but I doubt that's going to happen. But if it does, we're the ones to say yes or no. So we have the control there in terms of how expansive this becomes. This right now is very, very narrow, and our record would show it's very, very narrow.
Thank you, Governor Stevens. Governor Adewale again.
Yes, Mr. President, I want to put on record that none of us governors that have spoken on this issue this morning have in one way or the other expressed any disrespect to our senior learned colleagues of this profession that we hold in high regard. I believe that that was not the intent of Governor Williams-Root or any of us, or Governor Higginson or myself or any of us. This forum is meant for us to dispassionately approach this issue that comes before us with objectivity and concerns, and we just express our concerns. So if I didn't see anything in any of our statement, and if that appears to be that way to Governor Stevens, I personally apologize. And I didn't, each and every, there's an African adage that says that you can have as many clothes as the elders, but you will never have the wisdom of the elders. That's an African wisdom for you. You know, so that was not the intent of each and any of us to slight or to insult or to disparage any of our senior colleagues, because all of us are going to be there one day. Like Governor Higginson said, all of us are bound by nature and life to be there one day. Now, having said that, Governor Stevens said something that resonates with me, that give it to the sections. And that is exactly where I'm going with this. If we really want to give it to the sections, why are we dictating to the sections? You get to pick these people as chairs or co-chairs or voting members. Why, if we really want to give it to the sections to determine, to use this as an opportunity to build their membership and to get experienced members involved in sections, then just make it plain that the Board of Governors, write it in a plain. Don't say, oh, you get to allow them to be chair or co-chair or have voting members. Each sections get to control who will be their members, who will be their chair. Because some sections can decide that we don't think that, you know, inactive members will play any role with us. So why don't we just say that? If we want to empower sections to be able to make that decisions, why are we dictating in this rule that that inactive members get to be chair or co-chair? So that's a question I have for Governor Stevens, or any other presenters here, if they are able to answer that question.
Okay, thank you, Governor Adewale. Eleanor Dorman, you have your hand up.
Yes, I wanted to share the experience of the senior lawyer section in part to counter the idea that senior lawyers are resistant to change, can't use technology, those kinds of issues, and share our experience during COVID. Because it, you know, pushed the issue of how we use technology as an executive committee. And these are people aged probably 60 to 90. We had to learn how to use Zoom, and now we really like it, and we regularly. We have produced 3 online mini CLE seminars. They've been great success, have brought the section more income than we've had before and more members than we've had before. We transitioned our newsletter from a written paper newsletter, which is traditionally what was done, to a very nice electronic newsletter that's been sent out. And that's all done by a group of attorneys age 60 to 90 who probably, you know, maybe had to push the learning curve, but we had to, and we did. And so I want to share that experience because I'm very proud of it and would like people to know about it.
I don't have my mic on.
Mr. President?
I have my mic on. Miss Governor Stevens. Is there, there's somebody else?
It was Governor Adewale asked that we speak plainly about what we're going to do. And on page 66, I think it is plain. You know, it says that inactive members are not eligible to vote or hold office therein or serve on any committee or board, except an inactive member may vote and hold office in a bar section if a section's bylaws permit. And it says hold office. So that person would not necessarily be the chair or the vice chair, but there are trustees, there are, or at-large members, there are secretaries, there are other positions on the executive committee. The executive committee itself is a hold office in the section. So it's not just chairs or vice chairs, it's what people can do. But that's the line in the revised bylaw provision that speaks just to sections, says what they can do, but that it has to be something done by the section.
Anything else, Governor Stevens? Nope. Let's see. Did I see somebody's hand in the room? Nancy Hawkins wanted to speak, and then there are some chat comments. I don't know if people have been able to check those out.
As usual, I would like to thank Alec for being far more eloquent in his comments in defense of older lawyers than I would have been. He's always more careful in his language than I am. I wanted to challenge this issue about active versus inactive, because Rex, you don't like what I'm saying? When I pay my dues every year, I don't think I check off a box that says I work 50 hours a week, and I don't think any of you do. You get to be an active member because you pay a lot of money. That's the only reason. And there are plenty of lawyers who do pay their dues and are considered active when they're not active lawyers, when they are home on family leave, when they don't want to work as a lawyer anymore, whatever. They keep their dues up and they get that status as active lawyers. Deciding when you're 65 or 70 to become an inactive lawyer, I would suspect is entirely about money, because you get to be that age and suddenly your income is fixed. Maybe you're living on Social Security. Maybe you're supporting your elderly parents. Maybe you're supporting your children that haven't left home yet. So you make a decision that saving several $100s is in your family's financial interest, and you move to inactive status. And you may still be very active, whether it's through pro bono work, whether it's through volunteer work, or something else. But let's not forget that part of diversity is also financial concern, and making a decision that you need to put your money elsewhere or don't have the money is not a reflection of what you know or don't know, or what you can or can't contribute. And I too have war stories about being a new lawyer and having to teach one of the old guys that I rented from how to use the copier. And people teach me things now too, but that's only one tiny little aspect of what we do, because we let somebody who's 30 years old be active. They may not know how to talk to a client. They may not know how to make a cogent argument in court. That's something I learned in 40 years. So we have different knowledge, we have different skills, but I think this, the diversity aspect of moving from active to inactive is one we should support. We should recognize there are decisions that people make for financial reasons. And I do still want those older lawyers who have less money providing their knowledge at the section level. If anybody's concerned about too much takeover, make it a limit. You can only have up to 2 seniors or inactive members on your, for God's sakes, don't make it just seniors, or we'd go away. But you can say you can only have 2 inactive members. Use it as a test, see how it goes. I don't think you'll see a bunch of takeovers. I think we'll see that we won't lose the people that we've been relying on for so many years.
I think Governor Bell has his hand up.
Well, thank you, Mr. President. Just very briefly, I would like to thank Ms. Dorman for her presentation today. I also want to thank the members and the members of this board, as well as Ms. Hawkins, for the comments. I think it's extremely helpful. This conversation has persuaded me to support this proposal. I think going into this, I was a close no, and now I am a close yes. I hope it passes, and I hope it works well. Thank you, Mr. President.
Not seeing any other hands up, I do believe we may be ready for a roll call vote. Governor Abell.
Aye.
Governor Adwale.
Aye.
Governor Angeville.
Aye.
Governor Boyd. Governor Clark.
No.
Governor Couch.
Aye.
Governor Dresden.
Aye.
Governor Higginson.
No.
Governor McBride.
Aye.
Governor Peterson.
Yes, please.
Governor Pertzer. Aye. Governor Sayani.
Nay.
Governor Stevens.
Aye.
Governor Williams-Ruth.
No.
I count 9 yeses, 4 noes. And Governor Boyd had to do something else, so she didn't vote. The amendments pass. Thank you very much.